right, this is Attorney Sarah Holmes, and our presentation today is Are We Still Good? Checking in on partnership agreements and when to revisit them. All right, so first, before we get started, let me just give you a little background. Who am I? Why am I talking to you about this today? So I'm Attorney Sarah Holmes. I own a law firm that's called Holmes Business Law PC, based in Philadelphia and the suburbs. We're licensed to practice law in Pennsylvania and New Jersey. We help people with all the aspects of a startup business, such as entity formation, contracts, hiring employees, trademark registration, commercial leasing. And we also help many business owners that are already in business, and we help them with, I would call general counsel services, meaning, again, help them with their contracts. We help them grow, asset purchase agreements, acquiring other businesses, and things of that nature. I myself have been a business owner for 11 years now. Before I owned my law firm, I did own two other businesses. One was a small manufacturing company, and one was a retail business. Prior to that, I was a litigation attorney in a mid-sized law firm doing defense of product liability and personal injury claims on behalf of business owners. So I have been a licensed attorney for some time now, and now in my own firm, I'm dedicated to helping other business owners, particularly small and mid-sized businesses. All right, so when we talk about partnerships, first, we want to talk about what is the actual structure of the business. Does it have a legal structure? Because there's something called a partnership, which a lot of people will say they're in as soon as they have a business partner. And a partnership itself is not a formal legal entity. It's just as if you are a sole proprietor doing business yourself with no legal shell around you, no legal protection. The only difference being it's you and at least one other person. And when that's the case, it's called a partnership. Then there's a limited liability company, which most people know as an LLC. That can be owned by one member, in which case it would be a single member LLC, or that business can be owned by many members, in which case it's just a multi-member LLC. So that could be another structure in which you have business partners and different types of agreements. And finally, of course, there's a corporation. So a corporation is definitely a very formal entity. It's also known as an Inc. If you abbreviate it, it's incorporated. That has shareholders, and that can have many shareholders, or it could have one shareholder. It may have officers. It may have directors, but a corporation would be held by shareholders. All right, so the type of entity you have is what's actually going to control what type of documents you might have with business partners. So if you have a partnership, the type of thing that's the informal, but it's you and one other person at least, you might have a partnership agreement. And that could be just a general writing that talks about how you're coming together to do business. It might say, Jennifer owns 49%, Susie owns 51%, and they agree that they're going to come together and start an e-commerce business and split the profits according to their percentages. And then if one day they don't want to do business together anymore, they're just going to both go their separate ways and walk away. So partnership agreement could be any kind of writing between the two or more people outlining how they're going to do business together. Now, an LLC has its own documents, and those documents, if you have a limited liability company with a partner, are going to be called, number one, the operating agreement, and number two, a buy-sell agreement. And we'll get to what those mean in just a moment. And finally, if the business entity is a corporation, there's usually a shareholder agreement among the shareholders, and hopefully also a buy-sell agreement. Now, what are these documents? What are some critical clauses in here? All right, so we will talk about in all these things, either a partnership agreement, a shareholder agreement, or operating agreement. I've put up on the screen a few things that should be in these types of agreements that would be absolutely critical to have when you have business partner or partners. One is the equity split, and that means what percentage of this business does each person own? It's really important to spell out somewhere that, like I said, Jennifer owns 49% and Susie owns 51%. we need to know how that business is split up and what each person owns. If it's casual and informal, well, maybe I own 50, maybe you own 50. That's not good. That's not going to help. We want to make sure we're clear on what percentage of that business each partner or each shareholder or each member, depending on the entity, how much they own. Then secondly, there's voting rights. So there's a lot of different ways to do voting rights, and you can't assume that like if you used an online place that they got the voting rights correct. So one way to do voting rights would be majority rules, right? So in that case where we have Jennifer and Susie, Jennifer's 49, Susie's 51, a majority vote would mean that Susie's always in control because she owns 51%. That's majority vote. Then there's voting rights that are unanimous, meaning that everybody has to agree. So in the case of Jennifer and Susie, it doesn't matter that they're 51, 49. They both would have to agree to get anything done in this business. Not a great way to run a business, but you'd be surprised how many templates have unanimous votes in them. And finally, there's voting that's split according to the equity, meaning that Jennifer's vote is worth 49%, Susie's is worth 51%. That always means, again, that Susie's always going to be the deciding shareholder because she owns more, and that's split with her equity. Now, if they brought a third person in there and the votes are split according to the equity, let's say now we have 3 people and it's 33 and a third. Now each person only has 33 and a third voting percentage, meaning you always have to have two people to do it that way. The other way to do it would be to do a 1 vote per 1 person. So if you had 3 people, each person gets an equal vote. And, just by default, you're always going to have a majority. You're going to have 2 out of the 3. Whereas if you had 3 people, but 1 person has, say, 50% and the other 2 are 25-25, the equity again is going to go in favor of the person that's 50. It's not going to be even a majority vote because you've got 3 people, but you're going with the equity. So it's very important to spell out how exactly you're going to run the voting rights, because it does not have to go with the majority. It doesn't have to go with the equity, and it doesn't have to go 1 vote per person. You can do it however you want. Now, another important thing to have in these documents can be a non-compete. This is something that can come into play when you're taking on a business partner that already has another business or some outside interests. We see this a lot with people, with friends coming together to run a business. Maybe one of them is already in the industry and they're coming together now to do a new thing. A lot of questions will arise as to, all right, if you bring this new thing in, who owns it? Who gets rights over it? Can I go start something on the side on my own? Typically, you wouldn't be able to do that once you have business partners, but we can make that even more clear with a non-compete, and also have provisions in there that if one of the business partners were to leave the business, they could not leave and go set up a competing business. So that's definitely something to think about in a partnership agreement. There's also the duties of good faith and a fiduciary duty when you have business partners. That means that you always act with the utmost good faith towards your business partners. It generally means that if a new opportunity comes to you and it's relevant to that business that you're in a partnership with, you bring that opportunity to the business. You don't yourself take advantage of the opportunity on the side outside the business. Fiduciary duties means you have a financial duty to that business, meaning you should not be squandering the company funds for your own benefit. You obviously shouldn't be siphoning money off to yourself for that benefit. You have some monetary and important duties as a fiduciary, someone that protects the business and its financials, and that's something you're obligated to do among your business partners. Intellectual property rights, this is critical. We've had some people, this has come up recently as an issue for them. This would mean if someone in the business, one of the partners, invents something that has to do with the business, who does that invention belong to? Do not assume that that invention belongs to the business. It might not. That invention might belong to the individual person that invented it. And absent a written agreement or some kind of invention assignment, that's something that could potentially be up for debate for a long time, continuing way past the time that you are in business with these partners. So dealing with intellectual property in one of these partnership agreements is very important, and discussing who owns that. Also, deadlock provisions. Many people go into business being 50-50, and they feel like that's the best way to do it. It's fair. That's fine, but that creates a lot of problems, particularly around if the members or the shareholders have to vote on something and they can't agree. What happens then? They're 50-50, you're in a deadlock. So you want to have some kind of deadlock provisions for what's going to happen if you can't agree on something and can't come to a decision together. You need to appoint someone as a neutral third person. You need to get a mediator. You need to do something so that this business is not stuck in a deadlock. All right, a buy-sell agreement. Many people do not know what a buy-sell agreement is. When I mention that to them, they don't know what I'm talking about. They've never heard of it. We like to do these as a separate agreement, in addition to an operating agreement or in addition to a shareholder agreement. Sometimes you will find these provisions within the operating agreement or within the shareholder agreement. We just have a stylistic preference of putting it someplace separate because we feel like the buy-sell agreement is something that probably needs to be revisited on a fairly regular basis. And so it's easier for that to be in a standalone document. Now, what type of stuff goes in a buy-sell agreement? So number one are triggers. Identifying and defining certain triggers. So what happens in a buy-sell? What's the point of it? Well, the point of it is that if you think about having business partners and owning a business someone, it's like owning a house, right? You might own a house with someone, both of your names are on the deed, and one day maybe you break up and that person moves out. Well, until you buy them out or you refinance the house or you change the deed, their name is still on that deed. They still own that house with you, and they're going to do that until you take some legal action, even though they don't live there anymore and they've moved out. It's the same thing with a business. Someone that you're business partners with might quit working in the business. They might move away. They might actively stop participating in the business, but they still own that business with you until some legal event occurs to get them out of the business, like a buyout or it's usually a buyout or some type of expulsion clause. So the buy-sell agreement is going to outline what all of those circumstances are, where either somebody voluntarily or involuntarily needs to leave the business. Now, what are some voluntary reasons someone would need to leave a business? They wake up one day and they decide they want to move to another state. They don't want to be in this business anymore. They might say, hey, John, I don't want to be business partners anymore. I'm going to go start a new chapter of my life and move to California. I'd like you to buy me out. Okay, that's one voluntary. Another is retirement. Maybe, John has reached retirement age and he's like, I don't want to do this anymore. Okay, it's time to buy me out. Involuntary. There's a lot of involuntary triggers. Death of a business partner, incapacitation of a business partner, disability, bankruptcy, divorce. These are all things that would cause your business partner's ownership interest to go to someone else that you don't necessarily want to be business partners with. For example, in the event of a bankruptcy, that could be a bankruptcy trustee. They have seized your partner's business interest, and the bankruptcy trustee is now your business partner. Divorce is a big one. The family court has awarded half of your partner's business interest to his ex-spouse. Now the ex-spouse is your business partner. These are things that generally people don't want. And so they want to have a legal document that says, if any of these things happen, these people cannot become my new business partner. They need to get out, and here's how much I need to pay them. So that's where valuation comes in. Valuation would be, all right, one of these triggers has happened. Let's say, unfortunately, your business partner died and their half of the business went to their estate. Okay. You now have to buy out their estate. So you have to say, how much do I have to pay the estate to get them out of this business? And that's where a valuation formula or clause will come in. And there's a million different ways to do this. And that's why it's really important to have that listed in the document, because otherwise there's just going to be a big, huge fight over what that business is worth and what you would have to pay someone and those payment terms. Another important thing to have in a buy-sell agreement is a spousal consent, meaning someone's spouse didn't know that these were in a document and affected their rights. Why is that important? Well, in that divorce example, if the family court awards part of your partner's share to their ex-spouse or soon to be ex-spouse, that's an important thing. And it's an important thing for the spouse to know. So if you get the spouse to sign off on this buy-sell agreement by having them sign a spousal consent, it becomes more difficult later for them to come back and say, hey, my husband did this without my consent. I didn't even know he owned part of a business. I didn't know that, I couldn't remain in the business. So the more you can paper that up on the front end, the better off you could be if that situation were ever to arise. So there's some important clauses to have in a buy-sell agreement. Now, when should you revisit terms of either a partnership agreement, an operating agreement, a shareholder agreement, or a buy-sell agreement? Well, number one would be you don't have any terms, meaning, you and your business partner have a handshake deal. Maybe you just have a collection of emails. Like you don't actually have anything in a formal written legal document. That's definitely a sign that you need to get some terms on paper. Number two would be you had an online service draft the terms. Many people use one of those low-cost online formation services. That's fine, except when you have partners and they give you an operating agreement that you've never read, you don't know what the terms are in there. Most people are very upset when they have a problem, a few years down the road, and they find out that all the provisions in their operating agreement state that the votes have to be unanimous. Well, that can be a big problem, especially if you're the majority owner. So if you've had an online service give you some stock template of terms that you've never read, definitely time to drag those out and revisit them. Same thing, you've never read the terms. You don't know what they say. Clearly time to do that. Get this on track. You're thinking about making a move soon. You want to retire. Maybe you're thinking of breaking up with your business partner. Maybe on the positive side of things, you and your partner are discussing merging with a new business. Maybe you're talking about bringing on a new partner. These are all critical times, or an investor. These are critical times now to take these out and see what they really say, because the last thing you want to do is bring in a new partner or investor that's going to be bound by these terms. And again, you have no idea what they say. You bring in a new investor, the terms say unanimous, and now this new investor or new partner is gumming up your business. So any kind of big move coming in the future, it's time to take these agreements out and see what they really say. All right, obviously, if you need future help, we write these for people all the time. We're happy to review them. We're happy to mark them up. If you need to get in touch with us, our phone number is 215-482-0285. Our email is the info@phillysmallbusinesslawyer.com. And I'm happy to take some questions. I'll just stop the recording in the meantime while I check for some questions in the chat. And we're happy to help you. Again, it's Holmes Business Law PC, Sarah Holmes, and our domain is www.phillysmallbusinesslawyer.com. Thanks.